We might get started while everyone's joining in. Hello, everyone, and welcome to today's webinar. My name is Bridget Kelly. I'm a principal lawyer in the Howard Andrews, and I've got my colleague here today, Jasmine O'Brien from Sladen Legal. Today, we've got an interesting and novel topic for you, and we hope that you all get a lot out of today's presentation. We do have some interaction today with some case studies, so please have a device ready to log into Slido so you can participate in that throughout the webinar. And also there's a Q&A box on screen. If you have any questions during the presentation, please enter them in the box and we'll do our best to answer them subject to time at the end of the webinar. So let's get started and I'll hand over to Jasmine.
Fantastic. Thanks, Bridget. And obviously, thank you everyone for coming today. As Bridget touched on, it's a really novel topic and it's a great opportunity for our family law practice and our industrial relations practice to collaborate and do something together, which has been quite exciting for us to have something that overlaps to some extent. So we've got a lot to get through, and here's just a bit of a sense about what we want to touch on. Obviously, there's been some key legislative changes of late, and we're going to talk through what they are, particularly with respect to family and domestic violence leave for all employees, including casual employees, which is a pretty significant one. So we'll talk about what that entitlement is. Much like sick leave or other forms of leave, there is a notice and evidence requirement for family and domestic violence leave. It is obviously by nature a sensitive subject, but employers are still well within their rights to request evidence before paying the employees for that leave. Confidentiality obligations, we'll touch on those, but one key takeaway today is in respect of not recording family and domestic violence leave on payslips, and we'll talk about that. We'll touch on some work health and safety obligations, and Bridget will also, having regard to her experience in the family law space, we'll talk about how employers can best support employees who are dealing with the challenging circumstances of family violence. So what are the key changes? The key one is that every employee will get 10 days of paid family and domestic violence leave per year. That entitlement has started for many employers. It's fully phased in by 1 August 2023. All employees, including casuals, get it. And this is pretty big. As many of you will know, casual employees get a 25% loading for things that they don't get, like annual leave, personal leave and the like. But they'll get their 25% loading and they'll get their paid domestic violence entitlement. The logical conclusion there is that the Parliament hasn't wanted employees having to choose between getting paid and potentially being subject to a situation that could be causing them harm. But a big move there in terms of a leave entitlement being available to casuals. It must be paid at the full rate as distinct from the base rate. So what you would have got had you worked that day that was rostered. Understandably, employers are limited on how they can use evidence that's provided to them in connection with this leave. And most importantly, family and domestic violence can't be recorded on payslips. Obviously, if there's a coercion or control type situation going on, the perpetrator looks at the payslip, sees that the person's taken family and domestic violence leave. Logically, it's not going to end up too well in those circumstances. Put it through as ordinary hours. We'll touch on that as we move through this webinar. And we've got some expanded definitions that Bridget and myself will talk through. So what is the how is family and domestic violence defined under the Fair Work Act? Well, violent, threatening or other abusive behaviour by a close relative, member of the employee's household or a current or former intimate partner that seeks to coerce or control or cause the employee harm or to be fearful. My key takeaway from this definition was that it goes much further than an intimate relationship. So it makes sense when we're talking about family and domestic violence. So it is a broad definition that goes beyond those sorts of relationships.
Some examples of domestic violence could include physical violence, sexual abuse, financial abuse, verbal abuse, the psychological or emotional abuse, stalking and damage to property, and also serious neglect in situations or relationships of dependence. How is family violence defined in the Family Law Act? Well, it's very broad as well. It is similar to the definition under the Fair Work Act, and it's defined to mean violent, threatening, or other behaviour by a person that coerces or controls a member of the person's family or causes the family member to be fearful. So it includes behaviour that makes a family member fear for their safety of themselves or their property or another member of the family or even an animal such as a pet. Generally, family violence can be carried out by a spouse, a family member who provides support to another family member, adult children against their parents, young people against their parents, or even siblings. In family law, we typically include it for those who share an intimate relationship, so de facto couples and married couples, parents and children, or relatives by birth, marriage, or adoption, or people who treat you like a family member, such as a guardian or a carer, or some sort of family structure or within the cultural group. So examples of family violence under Family Law Act, similar, assault, sexual assault, stalking, so that's following someone or monitoring someone's movements, repeated derogatory taunts, so that's potentially putting someone down or making someone doubt themselves, intentionally damaging or destroying property, and that could be individually owned property or jointly owned property or even property owned by a third party, intentionally causing death or injury to an animal such as a pet, unreasonably denying financial autonomy or withholding financial support. So that's all about the control of money, potentially selling property without someone's consent, borrowing monies or creating debts in someone's name, trying to stop the family member from working, and basically taking away independence from a financial aspect. Also, another example is preventing a family member from making or keeping connections or depriving a family member of their liberty. So the Family Law Act goes on then to explain what is exposure of a child to family violence. So that's where a child sees or hears family violence or otherwise experiences the effects of family violence. And again, there's quite a few examples, but it's a child overhearing threats of death or personal injury to family members, seeing or hearing assaults between family members, being required to provide assistance to a family member who is a victim of family violence, cleaning up a site where family violence has been occurred, or being present when an officer, such as a police officer or an ambulance officer, has attended to assist a family member. So employees, not only being subject to family violence themselves, could be very concerned or stressed about the impact of family violence on their children. So there is quite a bit of interaction between family violence and family and domestic violence under the two legislation. It's not exactly the same wording, but it does interact. And the key similar words are on the screen there. It's violent behaviour, it's threatening behaviour, it could be coercive or controlling behaviour, and it's really making someone feel fearful. I think the Family Law Act is probably a little bit more descriptive, but they both interact and have the similar understanding of what the concept is.
And as I touched on, the paid entitlement comes into effect in 2 stages. And for businesses with 15 or more employees, that entitlement is in force now. For everybody else, and generally in recognition that smaller businesses need a larger grace period, more time to organise their affairs, make sure they've got the cash flow and the like. comes into effect on 1 August 2023. Between 1 Feb and 1 August, small business employees have an unpaid entitlement. But very soon, everyone will have the benefit of this entitlement, bar some narrow exclusions, which, having looked at the attendee list for today's webinar, aren't going to apply to your businesses. Now, I find this perhaps one of the more fascinating slides in this presentation, and a really interesting issue to ponder as we think about paid family and domestic violence leave. Because I think it's important to separate out what I think is fairly well accepted, which is that family and domestic violence is sort of horrible, impacts lives, and as a society, obviously, we want to make sure that that's not happening. And I get some clients saying to me, Jasmine, this is fantastic. I really think it's great that the federal government has legislated this. Equally, some clients say, I get and I understand the significance of this issue, but I don't understand why it becomes a workplace issue that I then need to stump up and pay 10 days per year of leave. And I think the answer is as much political as anything, because this was an election commitment of the incoming federal government. They said we will legislate 10 days for everybody. And you'll see ever since July 2018 on this timeline, it started off being an unpaid entitlement for some employees, became an unpaid entitlement for all employees, became a paid entitlement for some, and became a paid entitlement for all. The answer, and you don't necessarily need to agree with the answer, but the answer is that rightly or wrongly, workplace relations law recognises certain types of absences as warranting pay. That includes when you're sick, it includes bereavement leave, it includes sitting on a jury. It can include fighting fires in some instances. And this is essentially the legislation saying this is a significant societal issue, and because of that, employers should share the load. Prior to February 23, and this is, I think, where some of the resistance comes from, it was obviously open for businesses to allow employees to access their sick leave, to take time to deal with domestic violence issues, to grant paid leave on a special paid leave basis, or to come to some sort of other arrangement. And in those instances, generally that the employee is in the same position. I think what the legislation is doing is saying, well, we get that, but not all employers will do that. And we now want to bring the entitlement out across the board. I think it's now here to stay. I think the issue is too emotive when there's invariably a change of government for a new government to unwind that. I think the optics of that would look pretty poor, and much like trying to unwind things like annual leave and personal leave. Once the entitlement is there, it tends to be there. But that's the answer of how we've got where we got in terms of that legislative process. So having said that, what is the entitlement? And the entitlement sits with full-time, part-time and casual employees. One of the questions that I've been getting, perpetrators cannot access paid family and domestic violence leave, and I'll drill down on that shortly. So it's for the victims. Now, logically, you could have a circumstance where both parties to the relationship were saying that they were the victim, but for our purposes, you couldn't access this leave if you were effectively contesting an application that the victim had made. Now, national system employees only, all Victorian employees and national system employees, we're really just talking about a narrow cohort of state public servants in some states and Western Australia always does things differently, but largely all Victorian employees are national system employees. So what is the entitlement? What's quite novel about paid family and domestic violence leave is that it does not accrue. So as you know, you get your 10 days of sick leave per year for a full-time employee. You cannot take any sick leave for 10 years and all of a sudden you've got 100 days worth of leave. Family and domestic violence doesn't work like that. So if you don't use it, you lose it, to use a colloquial phrase. So you get 10 days at the start. So for most employees, they would have got their 10 days on 1 February 2023 when the entitlement came into force. It's not something that's steadily accruing across the course of the year. Now, excuse me. So if you don't access your 10 days by the end of that year, which will be 31 January 2024, you don't get another 10. Your entitlement stays at 10. Your entitlement can never be greater at 10. If you use 3 days over the course of the year, your entitlement will top up to 10 on that anniversary date, but it will never be greater than 10. But that's how that works. It's pro rata for part-time employees. Now, when can the leave be taken? And there are a couple of important concepts here. So the first is you need to be experiencing family violence. And that experiencing family violence reference, that's why the perpetrators can't take paid family and domestic violence leave. It has to deal with the impact of the family and domestic violence. And it must be something that's impractical to be done during normal business hours. Now, as we all know from our lives, there are a lot of things that can't be done outside normal business hours. And that might include attending medical, financial and legal appointments, for example, attending police interviews or attending court hearings. So there are some things by nature that can't be done in the evening. And it has to deal with the impact of that violence. That obviously can be incredibly broad. It could include counselling, it could include moving house, it could include various contingency plans to mitigate against domestic violence occurring. We've got some questions coming through. I'll just flag and we will deal with those at the end. We've certainly got a bit to go through, but I just want to acknowledge that. Now, so that's when the leave can be taken. It's a 3-step criteria. Experiencing, dealing with the impact, impractical outside work hours. So how's it paid? Annual leave, personal leave is paid at the base rate. This is paid at the full rate, which is essentially what you would have got had you worked that day. Would include things like overtime, include penalties and the like. Clear intent is that you're not disadvantaged for that. Now, casual employees, and this is the one I find really interesting. Once the casual is rostered, they get what they would have got had they been rostered to work. So that would include their casual loading. Now, I had a client say to me, they said, well, Jasmine, the casual employees, and this was a real bugbear. Why I'd just stop rostering them. I'd just stop rostering them if they know that they're not going to come, if I know they're not going to come into work, because I don't roster them, I don't have to pay them. So what that client would need to be careful about would be their reason for not rostering. And if they were rostering to avoid making the family and domestic violence leave payment, it would likely be a breach of the general protections provisions. So that client would need to be able to say, I haven't rostered them because I'm concerned about their reliability. It can be a fine line, but it wouldn't be open to that client to not roster them because of this entitlement. You'd have to not roster them for another reason. And that's certainly something that we've been working through with a few clients of late. Interaction with enterprise agreements or even interaction with employment contracts. If a business has conferred an entitlement and that entitlement is not as good as this new paid entitlement, that existing entitlement is read subject to this paid entitlement. So the paid entitlement is a minimum standard that applies to all employees. And basically that means that you can't derogate from that entitlement or contradict it in another document. So moving through to my favourite part of this presentation, some of you will have used Slido before. For those of you who have, I apologise, but for those of you who haven't, you can either scan that QR code with your device, or alternatively, you can go to slido.com and you'll be prompted to enter in that code. So we'll just give everyone a moment to do that, and then we'll move on to our case studies. You'll be asked to respond to the case study, it's obviously interesting to see what everybody says. I assure you it's anonymous, but we will talk through what the answers are once everybody has given their opinion.
All right, well, we might start with case study 1. So Joanne uses 2 days of family and domestic violence leave in March 2023 and 6 days leave in June 2023. Prior to March, Joanne had not taken any periods of family and domestic violence leave, but in November, she requests a further 3 days of leave to attend a court hearing. Her employer only grants 2 days, claiming that Joanne's family and domestic violence leave balance does not cover a 3-day absence.
So, is Joanne entitled to payment for the full 3 days? Yeah, still jumping around a little bit. Okay, we're almost bang on 50-50. Oh no. Well, we'll put you out of the misery. So there's a bit of a trick question. And it's designed to highlight the distinction between, say, compassionate leave, which is limited to 2 days per occasion, as distinct from family and domestic violence leave. So there's nothing stopping an employee from using their 10 days as a single block. So logically, it follows that if you can use your 10 days as a single block, you can use your 3 days as a single block. So in those circumstances, yes, Joanne would be entitled to payment for the full 3 days. But as you can see, if you've selected no, you're certainly not alone. And this is just the natural learning process of getting across a new entitlement. The entitlement never exceeds greater than 10 days, but also there's no prohibition on how the entitlement can be used in terms of blocks of time.
All right, so case study 2. Rebecca is a casual employee at a retail store. She's rostered on to work on Thursday from 9 until 3 in the upcoming roster. However, she forgot to notify her employer that she'd arranged for removalists to help her move on that day from the home that she's sharing with her partner and who she's experiencing family violence with. Rebecca tells her employer once the roster is published that she needs the Thursday off as family and domestic violence leave. Rebecca's employer tells her she can have the day off, but will not be paid because she is a casual employee.
Fantastic. So I'll move over to the question in a moment, but if you just take a moment to absorb that, because the question we're about to ask is Rebecca entitled to payment for her absence? Yes or no? Well, you've all been paying attention. And I think we've got now a bit of noise of affirmation going. So yes, and as you've all quite rightly picked up, the key word in that case study was rostered. And once that roster had been done and published, Rebecca's entitlement triggered. So well done, everyone. So what we want to touch on now are the notice and evidence requirements. These won't be new concepts to you because you're familiar, obviously, with notice and evidence in the context of sick leave. The reason we want to touch on it here is that, understandably, this is a sensitive subject. People have good intentions, generally. That obviously needs to be weighed against an employer's right to make sure that the leave is not being misused. So, logically, there are obligations on employees that need to be discharged before the entitlement becomes paid. So they've got to notify their employer as soon as practicable, but that can be after the leave has started. That's consistent with sick leave, for example, consistent with carers leave. There are obviously some instances where you can't give notification before the leave has started, and you've got to say how long you expect to take. So our case study before, that they would need to say, look, I think I need 3 days, for example. We can't say no. Say the employee might say 2 days, it ends up being 4. We can't say no to day 3 and 4 on that basis, but the employee does need to give an indication of how long they anticipate that they will take. Now, can we ask for evidence? Most definitely. Now, the default legal explanation or standard, which is often terribly unhelpful, is evidence that would satisfy a reasonable person. People say, well, what's a reasonable person? You say someone not acting unreasonably, and you get into this very circular debate. I think that what that really means is that the employee has got to provide something credible, but the employer can't take an overly legalistic view or overly technical view on what that evidence might include. Logically, they could include things like police documents, family violence support services documents, and stat decks. There might obviously be some instances where somebody just needs to escape or make some arrangements to extricate themselves from a situation that they're in that doesn't necessarily result in police documents or support services being accessed. And in those instances, a stat deck would be reasonable. Now, do you have to ask for evidence? Is another question that I get. No, you don't. You might think, do you know what? This is such a significant matter. It would not have been easy for that employee to share that with me. I'm going to give them the benefit of the doubt, and I'm not going to insist on evidence. You'll all be very familiar with that reasoning when it comes to sick leave. Sometimes someone's sick, they're sick, you're not going to say, look, trot off to the doctor and get a medical certificate for me. Take home point, you're allowed to ask for evidence because that is your safeguard against the leave entitlement not being misused. You do not have to ask for evidence. And there'll be logical reasons why many businesses don't ask for evidence. So moving on to our next case study.
Case study 3. So Tom requests to take 3 days of family and domestic violence leave. Tom's employer asks for evidence of Tom's need to take that leave. Tom refuses to provide any evidence, and his employer subsequently does not grant the leave. When Tom is paid, he notices that he's not being paid for the 3 days and that he requested to take, and then Tom complains to his employer.
So Tom comes to his employer with a grievance, and you are tasked with the answer of the question, is Tom entitled to payment for his absence? And I think the key word in that question is the word entitled. And Tom would not be entitled to payment for that absence because he has not provided evidence. That said, with two caveats, after the pay run has been done, Tom could go and get that evidence potentially. So he could go and complete a stat dec, or he could go and get some document which would be reasonable evidence, and then Tom would get paid in the next pay run. The other caveat is that the employer might say, well, look, do you know what? I'm just going to pay it anyway. But if you were the lawyer getting the call saying, is Tom entitled to payment for his absence, you'd have to say no in those circumstances because the evidence had not been provided. So moving on to confidentiality obligations, and this is relatively uncontroversial. Just don't use, to paraphrase, don't use what is told to you in connection with these provisions for any other reason. There are some narrow exemptions. Probably the most likely in these circumstances is that disclosure is necessary to protect the, oh gosh, this is the joys of energy efficient buildings. So I apologise for that. The most likely one is that it might become necessary to protect the life, health and safety of the employee if they're in a very difficult situation, and disclosure might be necessary for their safety. Logically, if you've got a situation like that arise, that is where I would be seeking some advice pretty quickly. Every situation in that space is pretty bespoke towards the facts, and you're navigating what could potentially be a serious breach as distinct from a duty of care or a moral ethic. They're quite tricky situations. Many of you will be familiar with situations, for example, where an employee might reference self-harm, for example, and you've got to make a decision about contacting next of kin and the like. So they're obviously some pretty heavy decisions if you find yourself in that space. So moving on to our next case study.
Yes, so case study 4, Henry requests 1 day of family and domestic violence leave per week for the next 10 weeks in order to attend family counselling sessions. His employer grants his leave. A new project then comes up at work which Henry is interested in. The project requires the employees to attend the client site 1 day per week, and that's the day that Henry will be on his leave. He expresses his interest to his team manager, who's aware that Henry will be taking his family and domestic violence leave once a week for the next 10 weeks. Henry's manager tells him that he is not eligible to participate because he will be absent from work on the day that he would be required to attend the client site.
So a lot in that one, and I'll just give you a moment to absorb it before we move on to the question. And so our question here, can the employer refuse Henry's participation in the project? We've got Henry, he's using his leave, but we've got a client requirement too. Still bouncing around a bit. A bit of a late surge with the nose. Really interesting. The last time Bridget and I did this webinar, we got a 50-50 split. I think that the attendees on this call are a bit more bolshy, but I'm also with the yeses as well. And I want to talk through my reasoning, and I'll also touch on the very credible reasons why some people might have ticked no, and touch on, I think, what some of the people who ticked no would have had at front of mind. So can the employer refuse Henry's participation in the project? Well, here we've got a lawful exercise of a right. No one's quibbling with that. The employer grants the leave. Henry needs the leave. Now, we've got a client requirement, and the client requires someone to be on site that day a week. And Henry can't go. He's got his leave entitlement. Now, a very clinical question: can the employer refuse Henry's participation in the project? The answer is yes, but I think we're missing a step there. So what I would say to Henry is, I'd say, Henry, we get and we acknowledge your leave. The project requires attendance on a Friday. Is there any possibility you can move that leave to another day of the week? That's logically the discussion that you would have with him. If he can't, Henry might be attending a program that's only run on Fridays, for example. It's just an unfortunate situation where Henry's leave will prevent him from participating in that project. And so ultimately the employer could refuse Henry's participation in the project. There is one caveat that I just want to give, and it comes back to the casual discussion we had earlier in the call. And that is, we'd have to make sure that we're refusing based on business grounds, as distinct from refusing because Henry accessed the leave. And I think to comfortably say that we were refusing on business grounds, that's where you'd have that initial conversation. Henry, can you do this in the evening? Can the leave be deferred? Is there another day? Because if not, we'll struggle to get you onto this project. But I thought that was a great example and shows some of the practical issues that can come out of the exercise of these entitlements. And very quickly, as I've touched on, don't put family and domestic violence on payslips for obvious reasons. Work health and safety obligations. As we all well know from the last couple of years, employers' work health and safety obligations extend to the home. Employees working from home, the home being a location where people can be subject to family and domestic violence. 1 hour call doesn't necessarily allow us to go into this in great depth, but as a take-home point, if you suspect that your employee is subject to domestic violence while they're at home, you do have work health and safety obligations in that context. You can require someone to work from the office. Bridget's going to touch on some of the support mechanisms shortly. But where there's a basis to suspect, and for reasons we'll hear, you might not always suspect, some of those work health and safety duties are enlivened.
So what can employers do to make their workplace safer? Well, they could screen incoming calls or emails for their employees. They could change working hours, days, or locations. They could also increase security measures at main gates or any gates or entrances to a workplace. Could develop some personal safety plans for an employee who is working from home, and obviously communicate regularly with that employee to touch base with them and ensure safe access to and from work. So how do I know if an employee is experiencing family violence? Well, the short answer is you may not actually know if they are until you're told by them with a request for their family and domestic violence leave. Sometimes there may be no indication at all that an employee is suffering from family violence. As outlined, family violence is very broad, and it's also extremely sensitive and personal to the employee. So it's likely to be kept very confidential to that employee. And even sometimes family members don't know if there is family violence in a household. My experience is that family violence is often not known into assisting a client, unless of course there's an intervention order that I'm aware of. There's a couple of reasons. You would often ask a client some information such as, is there any family violence that I need to be aware of? They may not necessarily tell you. There's often questions that I would ask, is it are you able to speak frankly with the other side? Is it amicable? Can you negotiate things between yourselves? So obviously where it is amicable, then negotiations between parties is ideal, but it's obviously not appropriate when there's family violence in place because of a whole range of things, but particularly because of potential for that power imbalance or that control or coercion, or someone not potentially having competence to speak up. If there's children involved, they'll often ask about their care arrangements. And of course, there's an obligation to ensure that children are not at risk of harm or at harm at all. And often I can ask about living arrangements as to who's living where. So even asking some specific questions, clients might not let me know or describe family violence. And sometimes it's often when I've dealt with a client for a while and then I gather that there has been family violence and potentially for quite some time. So even as a trusted advisor, clients don't necessarily tell me exactly what's been going on in the household. And so you as an employer may not know at all either. So people cannot realise that they're subjected to family violence, and that might sound strange, but it could be something that's just been happening for quite some time and someone's got used to it, even though it's not appropriate. They could also not want it to be interfering with their work and securing an income for themselves. So that's really important. Obviously, income is essential when you don't have family violence, but where family violence is applicable, then it's even more important because it could assist with moving out, counselling, costs for themselves. So because people may not know about it, or they're potentially embarrassed about it, about someone's behaviour at home, that their partner may act in a way, or because they lack confidence to talk about it with someone, you may not actually know that family violence is happening. So in a nutshell, it's not always evident if family violence is applicable, and you may not find out. But in saying that, there are potentially some signs or warning signs that there could be family violence. So that you might see in the workplace perhaps increased or unexplained lateness or absenteeism. There could be social withdrawal from potentially what someone would normally come to a social outing at work and doesn't anymore. There could be distressed phone calls or texts or messages. Unfortunately, there could be unexplained injuries, including bruising. There could also be a sudden drop in productivity or an inability to concentrate on work tasks, or even an inability to go away on work trips, if that's generally been the case previously.
So what can an employer do to help? Obviously, a policy where the entitlement is communicated. There's some clarification around the employer's position in respect of evidence, clarification and assurances of confidentiality is probably the most practical way from the employment side. We've got personal safety plans for employees experiencing family and domestic violence. It might involve an increase of the physical security of the workplace and potential changes to location. Training to managers, that might sound like a stock standard thing that you hear in every workplace relations presentation. But I think what the training really is there is ensuring that your managers are aware of the entitlement and are ready to respond to that immediate disclosure. This is what's happening in my life, because that split second before they can necessarily get on the phone to HR or arrange some more senior support or get some legal support is obviously going to be quite relevant in the employee's experience with how that company responds to their personal circumstances. And obviously, we're not specialists in this space. We don't need to pretend to be. An employee comes to you with complaining of a toothache and you don't put them in the dentist chair. So we don't need to pretend to be something that we don't. But just being conscious of what those services are and where we can send employees is a very practical measure that businesses can take.
So employees may not need any information from you, but you as an employer may have some information useful if someone does actually want some information from you. So There's Safe Steps, which is based in Victoria. It's a 24/7 response centre for crisis support, information and accommodation. There's Orange Door, which helps and supports for family violence, as well as families in need of support for the wellbeing and development of children. There's the Sexual Assault Crisis Line, which is crisis counselling again, but for people who've experienced both past and recent sexual assault. There's the Men's Referral Service. So that's a confidential support service for people at risk of using family violence. There's the Kids Helpline, and that's a 24/7 phone and counselling online service for people aged between 5 and 25. So you might have some employees in that age bracket. And of course, there's the Employee Assistance Program, so EAP, which is counselling offered through your organisation to assist employees for any matters. So remind staff that it's available for use if they would like it. And of course, a referral to a family lawyer. So ideally, your employer will have an experienced family lawyer to assist them in family law matters, particularly where family violence is involved, to help arrangements for if it's intervention orders or for children, or also the division of relationship assets. That list is by no means exhaustive. There's many services available, and perhaps have a look in your geographical area as to what might be applicable for you, that you can, where your organisation operates. And of course, leave could be sought for any of those for employees to access those services that's appropriate for them. So next, we thought we'd just touch on intervention orders and the Federal and Circuit Family Court. So intervention orders protect the person who's applying for family violence. So it can help protect a person and their family from someone who's violent or makes that person feel unsafe. It's actually dealt with under the Family Violence Protection Act, which is the Victorian State Act. And the wording for family violence is similar again to the Fair Work Act and also the Family Law Act. It will include the name of the perpetrator and also the victim of the family violence. And intervention orders have three main stages. So the first stage is applying for an intervention order. So the applicant will complete an application form that's either at the local Geelong Magistrates Court or any Magistrates Court in your area, or online. They'll then have an interview with the registrar, who will complete any things that need to be completed and also then process that application. If it's urgent, it can be allocated before the magistrate on the day, and the magistrate can make a decision as to whether an interim order can be made. If it's not urgent or it's not approved as for an order to be made straight away, then it remains an application, and that has to be served on the respondent, and then the matter will come to court on what's called the first mention date. You can skip this stage if the police are called to a family violence incident, and they will prepare what's called a family violence safety notice, and they'll basically manage the intervention order process. That'll then have to go before the court as well. So in terms of the first court date will be the mention court date, and that's where the person who served with the application must come to the court, and they must decide what's going to happen with that application. That may sound a bit strange, but the applicant has applied for it, and it's up to the respondent as to whether they'll agree or not to that order. So there's three things they can do. They can agree to the order wholly, and an order is made, and that's the end of the matter. They can agree to the order, but there's no finding of fact. So what that means is they're agreeing, but they're not admitting to any of the allegations that have been contained in the application. Again, that'll be an order, and that'll be the end of the matter. If they don't agree with the application and they don't want to agree to an order, it'll get set down for the next court date, which is a directions hearing. And at the directions hearing, basically the court will hear a little bit more about what the matter is. The applicant will have to file a document called a further and better particulars, which sets out in more detail the allegations that they've made and what evidence they have to substantiate family violence being undertaken or being perpetrated against them. And the respondent has to reply. If the matter still doesn't resolve, then it's set down for a contested hearing. And that's where the applicant will bring themselves plus any witnesses to the court, and they will give evidence in a witness box, and the magistrate will make a decision and a determination as to whether family violence has been proven or not. If an order is made, It will have an expiry date. In very rare instances, there is it continues on indefinitely, but most times they'll be valid for about 12 months, sometimes 2 years. So an employee could use their family and domestic violence leave for any of these stages in terms of the intervention order process. So then what's included on an intervention order? It includes the protected person's name and children if they're what's called affected family members. It'll include the name of the person who the order is made against. It'll say how long it's going to last. It'll also include a number of conditions, which I'll go through. And it also says, importantly, whether the person who the order is made against was at court when the order was made, because if it's an interim order, they wouldn't be at court. And also if the order is made with a denial of the allegations. And again, that's important because if there hasn't been a finding of fact in relation to family violence, that can, it's important in terms of other family law matters as to whether that's been there or not. And then in terms of conditions on an intervention order, so you can have a whole range of conditions on an intervention order. Basically, what it's trying to do is to ensure that the applicant feels safe. Some usual terms would be not committing family violence, which sounds silly because you're not allowed to commit family violence, but it is usually included in the order. Not intentionally damaging someone's property or threatening to do so. Not attempting to locate or follow the protected person. So that's that stalking component. Not publishing on the internet or by email or other electronic communication about the protected person. So that's important. That's sometimes where people get tripped up because people might, for argument's sake, post pictures of their children on Facebook, and that can be a breach of an intervention order if that's applicable on their intervention order. Importantly, cannot contact or communicate with a protected person. That again includes any form of communication. So it could be written as in a letter, it could be email, could be text messages, could be phone calls. It's any type of communication. Not approaching or remaining within a certain distance of someone. So usually that would be about 5 meters. And not going to or remaining within a certain distance of where the protected person lives, works, or attends school or childcare. So that could be applicable to you, that the person named in the order isn't able to come anywhere near the workplace. Typically the distances might be 100 meters or 200 meters. And interesting, you can't get anyone else to do anything that the person is not able to do on the order. Can also have other inclusions in there like cancelling weapons licenses or forfeiting weapons and also return of items to someone's home. So it's quite extensive, and as I said, it's basically to ensure that the applicant feels safe. And then nextly, talking about family violence in the Federal Circuit and Family Court of Australia. So as I said, the intervention order is in relation to the state jurisdiction. The Federal Circuit and Family Court of Australia is federal jurisdiction. It can also deal with restraints like intervention orders, but of course the intervention order process is usually more streamlined, quicker and more cost effective. But what is good for the Federal Circuit and Family Court of Australia is it can restrain someone from damaging property or disposing of property which can impact on a property settlement division. So, of course, as we said, family violence can extend to financial matters, and this court is very useful in ensuring that property is secured and that an asset pool is not depleted or disposed of. Because sometimes a party will act against a division of property to reduce that so that the other party, the victim of the family violence, isn't able to receive their rightful entitlement in terms of a division of relationship assets. So it's a good tool that can be used as that financial component to protect someone who's the victim of family violence. And listed on the screen there is some of the standard court dates that's applicable. So the first return date, a directions hearing date, an interim hearing, a mediation, and that's where if there is family violence, the court is very good at ensuring that parties are kept in separate venues, and they've got a lot of rules and requirements in relation to when family violence is applicable in a matter, but certainly parties won't be required to be in the same room to participate in a mediation. There could be other further court dates and also a final hearing. Sometimes matters do get to that stage. So someone, an employee could apply for leave on any of those dates if they do have a financial aspect where they're saying that they're the victim of financial abuse through the family violence provisions. And so that brings us up to the key reminders today. So just recapping, so all employees, full-time, part-time and casual, are now entitled to 10 days of paid family and domestic violence leave each year. It's come into effect on the 1st of February 2023 and small businesses is the 1st of August this year. Employees must be paid their full rate of pay. Employees must keep evidence confidential, very important, including how it's reported on pay slips. Employers should be mindful of their work, for the obligations to ensure that they're providing a safe environment for employees, and employers should ensure that they support employees suffering from family domestic violence and update policies as necessary.
Fantastic. And in the time we've got left, I just want to address a couple of the questions that have come through. We've had one very good one about when the leave resets or when the leave is credited. Is it the employee's work anniversary or calendar year? Well, I'll answer that in three parts. For anyone employed at 1 Feb, when you got it, so large businesses, your anniversary date for this entitlement will be 31 January or 1 February, however, which way you cut it, in perpetuity. For anyone who gets the entitlement for the first time on 1 August this year, 1 August will become your key date by which the leave resets and then is recredited. Anyone hired after 1 August in a large or small business, your anniversary date will be the date on which the leave is recredited. So existing employees, the anniversary date is when the leave came into force. Anyone hired after it coming into force, your hire date will be your anniversary date. And the big question, it's a really good and it's a really honest question, and it goes towards some of the issues around it becoming a paid entitlement for everyone. How do we know or prove a person's claim to be false? The honest answer is you probably can't. And that's because if someone's going to, if I can just talk candidly, if they're going to misuse this leave, they're probably going to lie on a stat deck. And if they're prepared to lie on a stat deck, it's going to be very, very challenging for you to push back on that. All I can say is that if you've got somebody who is repeatedly using the leave, that notion of what is reasonable evidence probably moves into a more onerous form of evidence. But it goes towards some of the contention and some of the conjecture about what employers had largely dealt with on an ad hoc basis, becoming an entitlement for everybody. So that's all we've got time for today. It's a very meaty, very topical issue. And thank you everyone for joining us.
Thank you, everyone.
Bye-bye.
Bye-bye.